Everybody, this is Steve Lundberg, president of Schwegman Lundberg Wissner, and I am very happy to welcome you all today to the first webinar in SLW's Institute's International IP Webinar Series. This particular webinar is grant and validation process for EPO patents. The speakers today are Karen McCartney and Bryn Williams from our UK office. And Karen is a senior paralegal for Schwegman UK office. She's worked with the UK IP profession for 25 years, and she has a wealth of formalities, knowledge, and experience. Karen is recognized across the UK profession in her field and has contributed to the build and development of multiple docketing systems. Karen also is responsible for the patent and trademark paralegal and administration teams covering all aspects of IP prosecution before the EPO and the United Kingdom Intellectual Property Office, from filing through examination to grant. So welcome to Karen, and thank you for being with us today. And also speaking today is Bryn Williams, and Bryn's a chartered and European patent attorney, European trademark attorney, and a European design attorney based in the UK. On our team, Bryn has a bachelor's degree in mechanical engineering from the University of Glasgow and a master's degree in polymer science and engineering from the Technical University of Delft in the Netherlands. And Bryn entered the patent profession in 2002 after working as a senior engineer in the food and tobacco industries and subsequently as a commercialization manager at the University of Glasgow. So welcome to Bryn, and it's great to have you on the program as well. And in addition, I'd just like to put a plug in for our UK team. Schwegman has a team of 5 patent attorneys that work in the UK and file EP applications, and also work in the UK Patent Office and obviously do validations in Europe. That team spans across software, physics, electronics, and electrical, mechanical, med tech, and life sciences. And all the members of the team are highly experienced patent attorneys. We work closely with them for our clients here in the United States and bring a lot of efficiency through our close connection with that team by reducing the amount of overhead and communication, improving the communication between our UK advisors and our clients. In other words, we try to get rid of the middleman as much as possible, so that we're not playing telephone, relaying advice back and forth. And we've had a lot of success in bringing our UK professionals directly into contact with our US clients. And John Collins, who is one of our lead attorneys there and co-leads that office with Bryn, is a highly experienced patent attorney, 25 years plus, PhD in physics, and one of the renowned experts in software patenting in EP. So with that plug, I will turn it over to Karen and Bryn to take it away. Thank you. Thanks everybody for attending.
Thank you very much, Steve. As Steve said, my name is Bryn Williams, UK Principal for SLW UK, and I'm here with Karen McCartney, Senior Paralegal with SLW UK.
Hi everyone.
We are based in Glasgow in Scotland. We will try to speak slowly so that you can understand us. Okay, before we start, a geography lesson. The European Patent Convention covers 44 countries. There are 38 full member states. A European patent application filed today would automatically cover these 38 states. There are 2 further extension states, which can be covered upon payment of an extra fee. These are the 40 states which will be referred to in this presentation as the key member states. In addition, there are 4 countries in which a European patent, once granted, can be validated. As you can see from the map, these validation states include non-European countries, Morocco and Tunisia in North Africa, and Cambodia in Southeast Asia. Georgia is likely to join these 4 validation states in the near future. Let me clear up one misconception. The coverage of the European Patent Convention is different to the coverage of the European Union. The European Patent Convention covers more countries than are in the European Union. The European Union consists of 28 states, as shown on the next slide. This is important because, as you're probably aware, the UK is trying to leave the European Union following the 2016 referendum, a process known as Brexit. Brexit is proving extremely difficult, and it is still unclear whether Brexit will actually come to fruition. However, whether Brexit happens or not, it will have little bearing on the grant invalidation before the European Patent Office, because the UK is a member of the European Patent Convention, irrespective of whether it is a member of the European Union. Now you're up to speed in geography, let's start looking at European patent grant invalidation.
The European patent grant invalidation process can be considered a three-stage process, which is driven by two documents. Stage one is the acceptance of the text, which is driven by the receipt of the intention to grant a European patent, the equivalent to the US Notice of Allowance. Stage two is the grant stage, which is the period between the issuance of the decision to grant document and the grant date. Stage three is the validation stage, which is the period following the date of grant. We will discuss each of these stages in turn.
This is an example of the intention to grant document, intention to grant communication issued under stage one by the European Patent Office. This is the equivalent to a notice of allowance issued by the USPTO. The intention to grant communication is issued under Rule 71.3 and is also known as a Druck Exemplar or Form 2004C.
The intention to grant is an invitation to complete these tasks. The primary tasks are to approve the text and verify the bibliographic data. We will discuss both of these in more detail in the next slide. With regards to translations, to issue a patent grant certificate, the European Patent Office require all patents to show the claims in each of the official languages, that is, English, French and German. So, for an English language case, the translations of the claims into both French and German are required. In addition, a grant and publishing fee, similar to the US issue fee, is due. Further fees for excess claims and page printing may be required, and these will be shown on the intention to grant.
Care must be taken to ensure that the text is in line with the client's expectations and includes previously filed amendments. This is vital because this document will be the basis for the granted patent and is the legal text on which any litigation will be conducted. Therefore, it has to be correct. Unlike the US, the European printed copy is not the official patent. Checking is also important because it has been known for pages to go missing. You must ensure that all text and drawings are present. If the approved text is not correct, then we have no choice but to reject the text and file corrections. In most cases, this will result in a further 71.3. However, if the corrections we file are significant, the examiner may reopen examination.
The approved text may not only include the last file amendments, it may also include examiner's amendments. If the examiner has made amendments to the text, for example, to comply with formal requirements of the European Patent Convention, or correct typographical errors he has noticed. If such amendments have been made, their location is cited on the communication. These amendments need to be checked to ensure they are acceptable to the client. If not, the text needs to be rejected.
As well as checking the content of the application text, it is important to check the current bibliographic data is correct, as shown on Form 2056 attached to the intention to grant. Responding to the intention to grant is, in effect, the final opportunity to correct any defects centrally at the European Patent Office prior to grant. Assignments, transfers or changes recorded centrally at the EPO will, if recorded before grant, automatically be on record at the offices of the validated states. If the opportunity is not taken, defects will have to be corrected for each individual national office. Correcting before all the national offices can be very costly.
It may be desired to delay final grant of a European patent for any of these reasons: filing a divisional, registering change in applicant details, reducing renewal costs, or helping clients with their cash flow. Once we approve the text, file the translations, and pay the fees, the timeline is out of our control. The case will go to grant in due course, and we cannot exercise any control over when that will be. So, if for any reasons on this slide you wish to delay grant, then this is the time to do so.
As there is no automatic extension to the deadline for filing the response to the 71.3, the options are to allow the current 71.3 to enter further processing, or make a minor correction to the current 71.3 and request a further 71.3. Further processing will be discussed in more detail in the next slide.
The docketing requirements for a 71.3 communication are as follows. The EPO sets a 4-month term for responding to the intention to grant. The EPO 10-day mailing rule applies. So the due date is calculated by adding 10 days to the mailing date and then a further 4 months to that date. We are often asked, what is the purpose of the 10-day rule? It is intended to compensate for postal delays. The European Patent Office assume that 10 days is the worst case scenario, and even the slowest mail service will manage to deliver within 10 days. There is no option to extend the 4-month response time. However, if the deadline is missed, the EPO will inform you of the missed action and allow the case to go into further processing. Further processing provides an opportunity to restore the case with no loss of rights, as long as all of the tasks and the intention to grant are completed. These tasks must be completed within the period allowed for further processing, that is 2 months. The 10-day rule applies to further processing. A further processing fee of €255 must also be paid.
Moving on to stage 2, the grant stage. Assuming an acceptable response to the intention to grant has been filed, the examiner will issue the decision to grant under Article 97(1) EPC. The decision to grant is issued in Form 2006 and states that the patent will be granted based on the documents attached to the intention to grant. This is why we have to be certain that the intention to grant text is accurate and reflects the client's wishes. Further down the page, this document states the date of mention of grant in the European Patent Bulletin, shown in red on your screen. This date is the grant date, and it is important for 2 reasons.
The first reason is the grant date sets the deadline for filing divisional European applications. Divisional applications have to be filed whilst the parent application is still pending. Before the deadline for filing a divisional application, the deadline for filing a divisional application is the day prior to the grant date. On the grant date, the application has become a patent. Therefore, it is too late to file a divisional. The second reason is the grant date is important as it sets the deadline for completing the validation process. Validation is separating the granted European patent into national European patents, in a similar way to nationalisation of a PCT application into national patent applications. The validation stage is stage 3 of our process. All validations must be complete no more than 3 months from the grant date. This deadline is not extendable. If missed, the validation can only be revived by successfully restoring under national laws in each country. Succeeding in a restoration action is an extremely difficult and expensive process.
Something to consider is when will the renewal date fall due. For a European patent, the renewal date falls on the anniversary of the filing date. And if this anniversary is before the grant date, the renewal fee is due to the European Patent Office. If the anniversary of the filing date is after the grant date, a renewal fee is due to each national office where validation is to take place. Good docketing practice should record that, depending on when the renewal date falls due, renewal payment is either a single fee to the European Patent Office or multiple fees to the national offices.
Take, for example, a case where the Year 5 renewal date falls due before the grant date. The renewal fee is therefore due to the European Patent Office and is approximately $1,085. However, if the renewal date has fallen after the grant date, and validation has taken place in France, Germany, the UK, the Netherlands, Italy, Spain and Ireland, the renewal fees alone for these patents would be in the region of $1,950 US. For the year of grant only, it may be possible to save the client some money by pushing the grant date out beyond the 5th year renewal date.
So how do we do this? As we said earlier, the only way to influence the grant date is during stage 1 of the process, before you file a positive response to the intention to grant. Once a positive response to the intention to grant is filed, the European Patent Office will process the response and issue the decision to grant, setting the grant date. In our experience, the period between filing the response to the intention to grant and the actual date of grant varies, but is never less than 4 weeks. Therefore, if you delay filing your response to the intention to grant until less than 4 weeks before the renewal date, you will, in our experience, push the grant date beyond the renewal date. If the renewal date is between 4 weeks and 12 weeks after the deadline for responding to the intention to grant, you could purposely not file a response to the intention to grant. This would trigger further processing, or alternatively you can file a minor correction and request a further 71(3). Either of these actions will push the grant date out further.
Validations must be completed within 3 months of the grant date. This is not extendable. Validation requirements vary from country to country.
The validation requirements are completed by either a local national associate or a European patent attorney firm who can work across multiple EPC jurisdictions. For example, Schwegman, Lundberg and Mujner UK can validate in France, Germany, Ireland and the UK without the need for third parties. National requirements vary from country to country and may include the payment of official fees to the National Office, or the filing of signed power forms by the patent holder, or lodging of translations of the approved text, or indeed appointing a local national address for service. As a client of a European patent attorney firm, the only requirement you will need to assist with is the filing of the signed power form. All other requirements will be met by your European counsel. For certain countries, the appointment of an address for service is not compulsory. However, we would always recommend appointing an address for service. This will ensure that all national documentation issued from the National Patent Office is directed to a specific point of contact. Should no address for service be appointed, there is a risk that any notifications issued are either sent to the original European Counsel, who is representative for the European application, or, as we've seen in the past, sent to the patent holder. By appointing an address for service, you can be assured that any notifications are sent to a specific point of contact.
When a renewal fee falls due within the validation term, an automatic extension is applied by each of the national patent offices in which a national renewal fee is due. This is normally extended until the validation deadline. The rule of thumb being, a renewal cannot be paid when the validation has either not yet been finalised or can still be done.
Before we go on to national requirements, a quick word about the London Agreement. I'll give you a moment to read this slide. It has long been the desire of the European Union to have a single European patent, which covers the entire Union without the need for national validations. The stumbling block has always been translations. The cost of translating into all the national states' languages is prohibitive when compared to the current system, which allows you to pick and choose which countries you wish to validate in, depending on your budget and your markets. The London Agreement was brought in to try and move the member states of the EPC towards some form of harmonisation in an effort to reduce translation burden on applicants.
This is our validation matrix. For each country, the matrix lists if a power of attorney form is required to appoint a local agent as an address for service. It also shows the translation requirements for that country. There are 3 levels of translation requirements. The first level covers countries which do not require translations. That is, they accept the European patent in the form it is granted. There are 8 countries in this bracket, and these countries are full signatories to the London Agreement. The second level covers countries which require the claims to be translated into their national language. These countries, known as claim translation countries, accept the description in the form that it is granted. The third level are the full translation countries, which require the entire granted European patent to be translated into their national language.
Your European attorney will handle the validation process on your behalf. However, there are some points to note to ensure you do not run out of time. For example, the original power of attorney is often required, and whilst this can be filed after the validation date, at least an electronic copy must be on file in Greece by the validation date. Referring back to our validation matrix, just to emphasise the point, of the 40 key member states of the EPC, 25 of them require powers of attorney. Greece is highlighted in red because of the requirement for an electronic copy to be filed by the deadline.
Translations which are ordered close to the deadline often incur urgency fees, and we strongly advise issuing early instructions, particularly for the full translation country.
This slide highlights the full translation countries on the validation matrix. Recent legislative changes in Hungary mean that it is moving from a claims translation country to a full translation country. This will lead to an increase in costs.
There are some cost savings to be made. Both Italy and San Marino require full translations, but share the common language of Italian. Therefore, only one Italian translation has to be prepared for both countries. Similarly, Greece and Cyprus both accept Greek translations, so a single Greek translation can be prepared for these 2 countries. This also applies in Serbia and Montenegro. Serbia requires a full translation, and the Serbian claims can also be filed in Montenegro, a claim translation country.
This slide is a rough and ready guide to the relative costs of validations in the 40 key member states of the EPC. The green countries are by far the cheapest, and these, not surprisingly, are the countries which have no translation requirements. The red countries are the most expensive countries and are generally full translation countries, Norway being the exception. The orange countries are the mid-cost countries. I emphasise the text at the bottom of the slide. These are indicative costs and greatly depend on the length of the description compared to the claims. A very long claim set will skew this table.
We mentioned earlier that the London Agreement was a stepping stone towards a single European patent which covers the 28 states of the European Union. The unitary patent is a further stage in this process, a single designation for the European Union member states. The reasoning behind the unitary patent is to reduce cost and streamline procedures. As I said, the translation costs are the sticking point, and not all union states are taking part. It may come into force in 2020 for some European Union countries.
So back to Brexit. With regards to patents, the only impact of Brexit will be on the unitary patent. The UK was intended to be part of the unitary patent. It follows that if the UK were to leave the Union, it will leave the unitary patent. However, as with all things related to Brexit, it's not that straightforward. The EPO have said the UK may be able to remain within the unitary patent. The politicians will decide.
You may wish to consider using SLW UK as your validation provider. The validation of a granted European patent can be carried out by any provider. It is not necessary to use the prosecution EPO representative. Often, validation by EPO representatives is costly and inefficient. SLW UK offers a low cost and efficient service for validation of European patents, even when SLW UK are not the EPO representatives. Our process is managed by qualified attorneys and experienced paralegals. We can appoint ourselves as a dress for service in 4 countries, avoiding the need to use associates. We do not drip feed documents. Documents such as powers of attorney are gathered and sent in batches. Finally, we operate with great flexibility and our processes can be tailored to client requirements.
So for those of you who are still awake, we can now take questions. I believe there's a question and answer facility on Zoom. There's no open questions at the minute. The questions come in. How hard is it to correct address? Okay.
The correction of an address is a simple process, and normally if this is done at the EPO, it will automatically follow through to the national offices.
There's a follow-up question to that. It's for applicants or inventors.
There is no formal requirement to record a change of address of an inventor at the EPO or nationally. It is more important that the applicant's details are correct in either the national registers or at the EPO.
Okay, there's a question from Michelle McCulloch. What is the process for registering in Gibraltar and other UK territories? Some of these countries have extension agreements with the UK, for example. A UK patent will extend into territories like Jersey and Guernsey. I'm not sure what Gibraltar's situation is, to be fair. Well, I imagine it'll be, it's not the European patent that gets validated in these countries. It would be the UK validation would then be extended into these countries.
In the experience that I have had, the registering in the UK territories is normally a simple administrative process, and normally that can be done quite simply after a grant.
Karen has said, will you be sharing the slide deck after this webinar? Yes, that will be available. We wait with bated breath for any further questions. One question that gets asked quite often from our US associates is the examiner can make amendments to the text which is attached to Rule 71.3. Can these amendments be substantive? They can, but it's very rare. Examiners' amendments generally tend to be typographical errors, structuring the claims in the preferred style of the European Patent Office, the 2-part claim, and things along those lines. A substantive amendment, if the examiner's got substantive amendments to make, he may take it into, he may take it back into prosecution. Okay, I think we seem to be done with the questions. So I think we'll just leave it there. Thank you for listening. I hope you've enjoyed it. We'll distribute the slides around. If there's any particular questions you want to ask, then you can email us directly through the Schwegman website. Thank you very much.
Thank you.